Each side will have equal time, but the state is entitled to divide their time between an opening argument and a rebuttal argument after the defense has spoken. I will tell you that we have gone over the jury instructions that I'm going to read to you after the closing arguments are done. I have a copy of it here. Each one of the lawyers have a copy. We have a copy for you each to get while I read them to you. So we all know what I'm going to read to you. So both sides may say, the judge will tell you first degree murder is that, or the instructions will say this. They would not mislead you. We all know what the instructions are going to be. All right, State, if you want to proceed.
Judge. Okay. Good afternoon, ladies and gentlemen of the jury. Beginning of this trial, I told you we would present evidence to prove to you beyond a reasonable doubt that this defendant, Qiu Feng, is guilty of murder in the first degree. And I submit to you we're at the point in the trial where that has happened. But you might be saying, we don't know what the state has to prove yet. We've heard a couple of things, so let's go over what the law is in regards to homicide and murder in the first degree. In the state of Florida, there are two types of homicides. There is lawful homicide and unlawful homicide. I'm just going to tell you that lawful homicide takes two different forms. Lawful homicide can either be justifiable homicide, which is a fancy way of saying self-defense. Everybody's familiar with the idea of self-defense. And excusable homicide is a fancy way of saying accident. So obviously, if it's a homicide, if somebody kills somebody else, and if it's self-defense or an accident, this is lawful. This is not unlawful. I want to go over with you a couple of things in regards to excusable homicide, because they came up earlier in jury selection. So, excusable homicide, and it gives three situations where this would be permitted. One is when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution without unlawful intent. All right? Keywords there, and you'll notice this in all of these, are accident and misfortune. Accident means something that does not happen on purpose. I'll give you an example. You're driving down the car, or you're driving a car down the road, going the speed limit, no problem, somebody just jumps out in front of you, you can't avoid them, you don't fall under this category. It's a homicide, technically, because one person has killed another. Is it excusable? Absolutely. Number two, when the killing occurs by accident and misfortune, in the heat of passion, upon any sudden and sufficient provocation. So again, you have that word accident, which means not intentional. And we talked about this, and somebody was asking, can you give a hypothetical? And I'm going to try. It's not far off from what Mr. Kuro was talking about in what here, but there's a key difference. Man comes home. His beloved wife, who he had no idea was cheating on him, is there in bed with his best friend. Shocked, he grabs his best friend, throws him off, his best friend ends up going through the window and dies. There was no intention for that to happen. There was action, there was violence, but under this prong, the law would excuse that situation. That is not at all what we have here. The last one, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. I'm not even going to go into that because that doesn't remotely apply. So, since this homicide is not justifiable self-defense or excusable accident, then it must fall into the category of unlawful homicide. And unlawful homicide, this defendant has been charged with murder in the first degree. So in order to prove murder in the first degree, the state has to prove three things. One, Edward Lee Tudor is dead. We all agree on that. There's even a stipulation that goes through that. That his body was examined by the medical examiner's office. We all agree that the person who was killed is Edward Lee Tudor. 2, the death was caused by the criminal act of Qiu Feng. And clearly, nobody is disputing that Mr. Qiu caused the death, and it's not justifiable and it's not excusable, so it is a criminal act. And 3, there was a premeditated killing of Edward Lee Tudor. Now, those are the only 3 things that the state has to prove to you beyond a reasonable doubt. Now, premeditated, we talked about this a little bit before in jury selection. And the law instructs that killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. So, again, we talked about this a lot. This can happen in the blink of an eye. And you may recall I used the example of baseball. There was a gentleman who was very knowledgeable about baseball, 60.5 feet. And the amount of time it takes that ball to get from the pitcher's mound to home plate, that people who are throwing the ball slower than the pros is less than half a second. The amount of time, or the time that you have to reflect on that decision is ample. Now, in this case, we have months of reflection, months of consideration, and ultimately, when he goes over there, armed with 2 firearms, enters the unlocked door to surprise Edward Lee Tudor, he has decided and reflected and made the decision he is going to kill Edward Lee Tudor. I'm going to talk a little bit more about that in a moment. Now, some other considerations you're going to be instructed on. I want to go over them with you so there's no confusion. An issue in this case is whether Qiu Feng did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, there are 5 things that must be true. A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. And quite frankly, you can stop right there and know that the rest of this does not apply, because there is no sudden event that happens here. All this stuff has been going on, according to the defendant, for a long period of time, and he's fed up with it. The only thing that happened that's new on January 23rd is he thinks that Jen is back. He thinks that he's got them back together, just like he wrote in his journal in 2017. Then I need to plan how to get Lee, my primary target, and Jen together. So you can stop right there, but I'm an attorney, so I'm going to go through all of them. B would be a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. Now, you'll also notice there's a trend in all of these, reasonable person. And nothing about the way this defendant acted in this whole set of circumstances is reasonable. C, there was not a reasonable amount of time for a reasonable person to cool off. Well, we know the defendant, he goes to get his will at 10:30. He's going to get another magazine around 11. He comes back. I mean, at some point in the morning, he was out in the yard just yelling at the other residents. There's been all kinds of time that's passed. And again, nothing here is reasonable. D, a reasonable person would not have cooled off before committing the act that caused death. Again, I'm starting to get redundant, but obviously not the facts in this case. And E, the defendant was in fact so provoked and did not cool off before he committed the act that caused the death of Edward Lee Tudor. I mean, none of that stuff happened in this case. And all that does, it's largely considerations against premeditation. Like, is it premeditated, meaning he planned to do this? Which he agrees on the record. He said on the stand, I meant to kill him. I'm trying to shoot him in the back of the head to kill him. Premeditation, or is it not because he wasn't thinking about the things? Because he was not able to. And the fact of the matter is, he was thinking about it the whole way through. He was thinking about how he needs to shoot him to get him to fall down so that he can shoot him in the back of the head. So, murder in the first degree, and I submit to you, the evidence shows the defendant is guilty of murder in the first degree, and there would be a box to check finding the defendant guilty of murder in the first degree, but that is not the only box that you have to check finding him guilty of murder in the first degree. There is an additional finding, and it's a little complicated, but not really. The additional finding is, did he discharge a firearm causing death? Absolutely. Now, you may recall the things I read you about how to prove murder in the first degree does not require a firearm. You can do it with a knife, you can do it with your hands, you can do it with a rope, but this defendant did it with a firearm, so it is necessary to have an additional finding that he did in fact use a firearm. You have it in evidence, he admitted he used it, he admitted he discharged it, he admitted he shot Mr. Tudor in the back of the head, and all the other times. So, to find him guilty of murder in the first degree, you must check yes, guilty of murder in the first degree, and check that he did discharge a firearm causing death. Now, the judge is also going to instruct you on what the law refers to as lesser included offenses, meaning crimes that are necessarily proved by, if we prove murder in the first degree, then there are other crimes that are included in that. And the crimes in this case are murder in the second degree and manslaughter. Now, we're going to jump out there and let you know the big difference between murder in the first degree and these other two, murder in the second degree and manslaughter, do not require any intent to kill. Murder in the second degree, same elements same first two elements, but the third element is a little different. It says there was an unlawful killing of Edward Lee Tudor by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. So you'll note, it does not include premeditation, it does not include any intent. In fact, it specifically says, in order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. And I'll give you a quick example of something that could be a murder in the second degree, which this is clearly not, is a person gets kicked out of a bar, they're upset, they're angry, they pull out a firearm and they fire some rounds into the window. Maybe thought the bar was closed, they didn't know there was a guy in there, that guy gets hit and killed. They did not intend to kill anybody, but they committed an action that's so egregious and done without any kind of care, with demonstrating a depraved mind without regard for human life, that the law holds them responsible for murder in the second degree. So again, that is not what we have here. And manslaughter is getting rid of that third element, just basically that Edward Lee Tudor is dead, and the defendant intentionally committed an act or acts that caused the death of Edward Lee Tudor. And we have more than that here. And your job as a jury is to find the defendant guilty of the highest charge proven. So, let's look at the evidence. Again, Edward Lee Tudor is dead, nobody disagrees. Edward Lee Tudor was killed by the criminal act of this defendant? Absolutely, we went over that. He agrees that he killed him, and it doesn't fall under any of the lawful justifications for homicide. So premeditation. What do you have to show premeditation? Well, first of all, the defendant agrees. In 2017, he wrote those words that you all heard us talk about. He wrote words such as, cunning and manipulative people like Lee disgust me. I am going to fight this to the end and give a lesson to all bullies to learn. The worst scenario would be a murder-suicide. I need to get this document done, he's referencing his type journal, so people will know why this murder-suicide happens. And then I need to plan how to get Lee, my primary target, and Jane together. Then I'll hang myself in my garage before cops arrive. He agrees that he wrote those words in 2017. It doesn't really matter when in 2017, because we know this offense occurred January 23rd of 2018. And at first I asked him, was it 2016? He said no, because the part where he references the dates, and I think I messed that up. I think I meant 2017. Frankly, it does not matter. Either one is a month, at least a month before, and either one shows this is his plan. We don't need to show that he planned it out, we just need to show that he did it with a premeditated design, but he actually was planning this out. So what happens? He sees, he realizes there is a woman there that we all know is Dakita Cox. He thinks it's Jen. So now, he needs to go make sure his will is notarized. That's part of the plan. He then needs to go to the pawn store and try and get more ammunition in case there's a firefight. And you heard the tape of what he said. You heard the detective describe for you what he said that day. And it's up to you guys to decide. Did he mean what he said when he said it on January 23rd of 2018? That he was concerned about a firefight, he needed to make sure he had all the ammunition possible? Or did he mean what he said today, which was he was just getting another, just needed another magazine to fill that spot? Now, he goes to get his will notarized, he goes to try and get more ammunition, and then he comes back home. He loads the guns. He walks across, and you can see him on video. He even checks his gun on the video camera so everyone can see, make sure it's loaded. He goes in, he confronts Lee, he shoots him. He's looking for Jen, but that's not enough. Now he's going to come out, and he's got to finish Lee off. He's thinking about, he wants to get him in the back of the head to end it. His words on the audio tape, to end it, he needs to end it. Because if Lee healed, he would laugh at the defendant. That is what he is thinking. He is reflecting. That is premeditation. He does not want Lee to be able to escape this encounter and laugh at it. Now, I don't think there's a whole lot to dispute about most of the evidence, otherwise I would review it in great detail, but I'm just going to go over with you. It's clear there was one shot in the living room near the bar. The shell casing is there. The projectile is up there. That would have been the first shot to hit Lee in the arm. We know that because we can see on the video that Lee stumbles out, favoring one arm and kind of keeping another one close to him. We know that the defendant chases him because we can watch it. We know that Lee is on his knees with his hands up when the defendant is pointing a gun at him, trying to get to the back of his head. We can both watch that. We've heard the defendant tell us that. And then we know that the defendant shoots him twice in the body and once in the head. And we know that because we have 3 shell casings right in front of where Edward Lee Tudor died. Now, the defendant cleared up a little issue in our timeline, because he actually goes upstairs twice. He then goes upstairs, he shoots the door to gain entrance, to look for Jen, and because that's where apparently he expected Jen would be, in the bedroom that he believed to be hers. And it was very interesting that he says, Jen, I was going to give a chance. I was going to give her a chance to tell me she's sorry and tell her what my problem was with her. Because he considered it. I was not going to do that for Lee. For Lee, it was, you know what you did. He was going to kill Lee as soon as he decided to walk over to that residence, and it didn't matter what Lee was going to say. It didn't matter what was going to happen. He was not going to give Lee an opportunity to respond. So then he goes back. You have the rope in evidence that he was going to use to complete his plan for the suicide portion. You have pictures of it hanging there. You have the will that was right there laid out next to it. And you have pictures of where all that stuff was. So, I'm going to talk to you just for a minute, but not that it's necessary with the overwhelming evidence in this case, but I told you we don't have to prove a motive, and we don't. However, based on the evidence and the defendant's testimony, we do know why he did what he did. Doesn't mean it's a good reason. It's almost never a good reason. It's nicer to think of things in terms of like, oh, someone was killed for money, insurance policy, or someone was sleeping with somebody else and the lover was used. Everybody's used to that. But this, why did the defendant do this? Pride and hatred. The defendant wants to see himself as a nice guy and a good neighbor. These were words, and we discussed them some when he was testifying. He does not want to view himself as the ordinary old guy next door yelling at kids to get off his lawn and to keep the music down. He does not want to see himself that way. So he turns Edward Lee Tudor, and apparently anybody else he lives next door to, into the scapegoat for his problems. He makes Lee into a boogeyman. All these things that happen, all these things that bother him, he attributes to Lee, he assigns to Lee motivations for doing these. Because then, Lee is the villain. Now, I'll give you an example. This is not very uncommon. You see this all over the place, perhaps not resulting in this type of situation, but I'll give you an example. Some of you may be familiar with Victor Hugo, an author in the 18th century. Some would say one of the greatest authors ever, and some would say that his opus novel is Les Miserables. In that story, towards the beginning, you have this character, Jean Valjean, who's gone through a life change and is largely the hero of the character, of the novel at this point. And he's a mayor of a city. And he has a factory that he's built up from nothing. And he's the owner of this factory. And he has managers and workers in this factory. And one of the workers is a woman named Fantine. And the workers and the managers aren't nice to her, and she loses her job. And life starts to go very badly for her. And she begins to assign all of these things that happened to her, her getting fired and the subsequent terribleness, to Jean Valjean. She's never really met him, just seen him in passing. She's never spoken to him, had a conversation, but she turns him into the villain in her mind, in this novel, a universal theme that we see, such to the point where when they do encounter each other later on, she's afraid of him and hateful to him. And actually turns to one of the villains to try and protect her from him. But that is exactly what this defendant did to Lee. Is he took all these things that were happening, He assigned them to Mr. Tudor, and he made Mr. Tudor the villain. Now, Lee probably didn't even know that there were much of a problem. He probably didn't give the defendant a second thought over there. He probably had no idea that this guy was in there stewing. In fact, you may have caught different snippets of some of their encounters. Lee probably thought he was being nice to this defendant. Was trying to be nice. He said, hey, Hurricane Irma happens. Are you good with the electricity? Do you need to use my generator? This defendant, Lee being nice to this guy, does not fit his conception, his concept of the villain, so that's going to be Lee manipulating him, trying to manipulate him. It can't be the fact that Lee's not a bad guy. Because then, the defendant couldn't be the hero of the story. The hero of the story standing up to the big bad Lee, the bully, the manipulator, the controller. And like, again, many times we see in literature or entertainment, the hero often sacrifices himself to take out the villain. That's what this defendant wanted to do. He wanted to take out Lee, and then he was going to commit suicide. And that's why he wants the law enforcement officers to know why he did it. He's given an interview with the news. He wants them to know why he did it. He took the stand in front of all of you, and he wants everybody to know why he did this, because Lee was evil. Lee was the villain, which makes him the hero. And the reality is, this defendant is not the hero. He's the other guy. He's the murderer. The reality is, he hated Lee. He wanted to win this war that he's so obsessed with that Lee doesn't even know is going on. And he wanted to make sure that Lee wouldn't survive to laugh at him. That's pride. Pride and hatred. I'll give you one more example. Oldest murder in the history of the world. Cain kills Abel. Why? Pride and hatred. Abel probably never saw it coming either. So when you go over all this evidence, and when you see the law that applies to this case, it is clear that the defendant is guilty beyond reasonable doubt. Now, we talked a lot about this in jury selection also. The defendant has rights. There are things that must be afforded to him, such as the presumption of innocence. Well, we are now at the point in the trial where the presumption of innocence is gone. You've heard the evidence. The evidence overwhelmingly overcomes that presumption. The defendant has a right to competent counsel. Mr. Pura is more than competent. The defendant has a right to a fair trial, and the judge is making sure that he gets that. But now, the people in the state of Florida, the state, the defendant, everybody is entitled to a verdict that is consistent with the law and the evidence. And I submit to you, the only verdict in this case that is consistent with the law and the evidence is that this defendant is guilty of murder in the first degree and that he discharged the firearm causing death. Thank you.